A very good evening to all of you. On behalf of the Income Tax Bar Association, Calcutta, the oldest tax bar association of India, being established in 1924, in collaboration with the Tax Advocates Association of Bengal and Legal Relief Society, we present before you our third webinar of the season on concept of settlement under the Income Tax Act 1961. We have with us Honorable Vice Chairman of the West Bengal Bar Council and also the Secretary of the Tax Advocates Association of Bengal, Sri Siddhartha Mukhopadhyay. And I would request Siddhartha da, once I unmute you, of course, to please give the inauguration address and formally inaugurate the program. And before that, I once again request all of you to please keep yourself unmuted as and when you would be required to speak. We would definitely ask you to unmute or do the honors. Thank you so much.
Thank you. Namaskar. I appreciate the endeavor of Sri S.K. Tulsian, the President of ITBA and Vice President of Tax Advocates Association of Bengal, in arranging 4-day webinar session jointly by ITBA, TAB and Legal Relief Society. Today is the third day of this session. It is our great pleasure to have with us Sri A.K. Jaiswal, Chairman of Settlement Commission, as the chief guest and speaker of this webinar. Welcome, sir. I hereby heartily welcome Sri Mithilesh, Commissioner of Income Tax Exemption, as the chairman to this insightful session. We are also glad to have Sri R.D. Kakra, Sri Manoj Kataruka, and Sri Siddhartha Rai with us. I am sure that we will enjoy the session today and come out more enriched with knowledge. Thank you all.
Thank you, Siddhartha da. I would now request Sri R.D. Kakra, on behalf of the Legal Relief Society, to please formally introduce the topic of the webinar. Mr. R.D. Kakra, please.
Friends, welcome to all once again. It's my proud privilege to introduce you about the subject matter of today's webinar. Today's webinar is a unique one, concept of settlement under Income Tax Act 1961. This complex subject is a unique one due to its usefulness, grant of immunity from prosecution, penalty, IPC, or any other central act. It's a one-time sanjeevani available to SSE for speedy settlement of his income tax cases and relax. In last 70 days of lockdown, we are the first to hold the webinar on this worthy subject. We are delighted that our today's chief guest and speaker, Sri A.K. Jaiswal, Honorable Chairman of Settlement Commission, will explain us the benefits and usefulness of this sanjeevani of income tax. We undoubtedly enriched with his lucid deliberation. Over to Mr. Roy.
Thank you, Kakraji. Thank you so much. And now I would request, without any further delay, Sri Sajjan Kumar Tulsian, the President of the Income Tax Bar Association, Calcutta, and also the Chief Patron of the Income Tax Settlement Commission Bar Association, to please welcome you on behalf of the hosts and formally introduce the Chairman of the session, Sri Mithilesh, Honorable Commissioner of Income Tax Exemptions. Sir.
Respected Vice Chairman, West Bengal Bar Council, Sri Siddhartha Mukherjee, respected Chairman R.D. Kakra, Legal Relief Society, the Honorable Chairman Settlement Commission, Sri A.K. Jaiswal, and our Chairman of the session, Sri Mithilesh Jha, CIT Exemption. Before I start to say something, I am really saddened at the martyrdom of our brave soldier at Galwan Height due to the uncalled for aggression by China. I, on behalf of my association, feel pained and convey my deepest sense of bereavement at the sad demise of our brave soldiers. I, on my behalf and on behalf of my association, do donate a sum of 2 lakh to the Armed Forces Relief Fund and mourn the death of our brave soldiers by observing 1 minute silence. So we will observe 1 minute silence in honor of the death of our brave soldiers. First. Today is a very big day for our association. We have today amongst us panel of 2 most distinguished officers from the IRS fraternity who will be enlightening us through their interaction on the scope of settlement under the Income Tax Act. While the chairman of the session, Sri Mithilesh Jha, who has also worked as secretary to the ITSC Kolkata bench, the speaker of the day, our chief guest, Sri A.K. Jaiswal, will be introduced by him. But as far as I am concerned, my task is today to introduce to you the chairman of the session, Sri Mithilesh Jha. Sri Mithilesh Jha, who is a Bachelor of Law and is in the Indian Revenue Service of 1990 batch. His present assignment is Commissioner of Income Tax Exemption, Kolkata. His antecedents are very noble. He is the grandson of Pandit Lakshmikant Jha, who was appointed as Attorney General of Bihar on 4th April 1948, who was directly appointed as Chief Justice of Patna High Court on 8th April 1950. It is the solitary instance that a lawyer has been appointed directly as Chief Justice of any High Court. Apart from working in various capacities in the field posting, he was deputed with the Enforcement Directorate during the sunset period of FERA and brought many investigations to its logical conclusion. His exposure to policy making during his deputation with the CBDT as well as OST to the Revenue Secretary were also path-breaking. As divisional head of the Cadre Management Division of CBDT, he executed the responsibility of managing the cadre of 57,000 employees of the IT department. This was done primarily by preparing the cadre review report of 2011. As Additional Commissioner of Income Tax Headquarter Administration for 3 years, he was in charge of the establishment section of Income Tax Department in the whole of the state of Rajasthan. He achieved the expectation of all employees by improvising a human resource management system which ensured that the promotions were done as per the model calendar and the officers and officials were promoted as soon as the vacancy arose. A letter of appreciation from the Staff Association of the Administration was high point of his tenure there. As Commissioner of Income Tax, He has worked in ITAT, CBO of a PSU, Secretary Settlement Commission, CIT TDS, and CIT Exemption. A member of the committee constituted by the CBDT, he was instrumental in introduction of online approval of the lower deduction certificates, CIT exemptions. The taxpayer service granting registration has been improved, and the time taken for grant of the various registration has been brought down to a month against the statutory requirement of 6 months. His mission as a public servant to ensure transparency and reduce litigation so as to ensure prompt delivery of services. A sum total, he is a dynamic officer with a great personality, and I'm sure under his chairmanship, today's webinar will be a grand success. With these, I hand over my back to the MOC, Sri Mr. Siddharth Ray.
I would now request Sri Jha to please take care of the proceedings, but can you please unmute yourself, Mr. Jha? Are you there? Sri Mithilesh Jha ji, are you there? Himadrida, can you find Mr. Jha? He had been there. I have seen him earlier. Did he got disconnected or something?
I think Tushanda is giving a ring. Let's wait for a bit.
Because he definitely did join earlier.
Unmute. Host unmute करेगा.
Yes. Mr. Jha is there, sir?
Sir. नहीं है मिस्टर झा हैं, मिस्टर झा हैं.
उसका क्या नाम से है वो? He has to rename probably.
नहीं, क्या नाम? मिथिलेश झा हैं, मिथिलेश झा हैं. मिथिलेश झा. बोले आईफोन के नाम से है. आईफोन.
हाँ, वो नेम थोड़ा रीनेम करने बोलिए, अदरवाइज. अच्छा, आईफोन. अच्छा.
हाँ.
So sir, I think now you're there, sir. Thank you. Sir, you need to read your entry. There's an option.
Okay. Now, but I think I have wasted some precious time in joining the meeting. So let me start right away. Am I audible?
Yes, absolutely you are.
Okay. So very good afternoon to all the participants. And I'm really thankful to the Income Tax Bar Association and the Tax Advocates Association of West Bengal in collaboration with the Legal Society to organize this webinar during the pandemic of Corona. So hats off to them and a real thank you to them. My locus standi to be here is as an officer of the department and my experience as secretary in the Income Tax Settlement Commission. In my view, the Settlement Commission is one of those great institutions under the Income Tax Act, which provides a single window clearance for the SSCs in matters of assessment, in matters of penalty and prosecution. So it is a great tool for providing taxpayer services whose reach, in my view, should be extended. So therefore, I thank the organizers of this webinar once again, because these kind of seminars will spread the awareness about the utility of such a great institution, which are being manned by the officers of impeccable integrity and merit, as the members of the Settlement Commission, and therefore it is in the fitness of things that the endeavor of spreading awareness about the Settlement Commission is lauded at the beginning. Having said that, it is my proud privilege to introduce Shri A.K. Jaiswal, Honorable Chairman of the Settlement Commission. Shri A.K. Jaiswal is an officer of the 1982 batch of Indian Revenue Service. He has given a continuous public service of 38 years to the citizens of India. And therefore, to introduce him in 5 minutes is a Herculean task. So I will confine myself to some of the basic things about his personality and his professional experience. He is a postgraduate in sociology from Delhi University. He holds a degree in law, and beyond these educational qualifications, he has also attended various prestigious training programs in Singapore and Australia, where he studied the taxation systems there. He has also attended the senior management course in Administrative Staff College of India, Hyderabad, and he has attended a training program on management at Harvard Business School in September 2015. Before joining the Settlement Commission on 13/11/2018, he has worked in various capacities and posts which entail serious responsibilities, as for example, the Principal Chief Commissioner of Income Tax, Ahmedabad, the Director General of Income Tax, Director General Investigation of Income Tax, Ahmedabad, Director General, Principal Commissioner of Income Tax, Central, Madhya Pradesh and Chhattisgarh, and Director General of Income Tax Investigation, Madhya Pradesh and Chhattisgarh. He has not only worked in the department, but he has wide exposure of experience outside the department as well. He has been an additional director of finance and administration with the Oil and Natural Gas Commission between 91 to 93. And he has also worked as the Deputy Director General of Narcotics Control Bureau from 2010 to 2015. So in short, Shri Jaiswal has wide exposure to the investigative techniques, administration of direct tax laws, and about the coordination between the different departments of Government of India while working as the Deputy Director General of Narcotics Control Bureau. Shri Jaiswal is a life member of Administrative Staff College of India, Hyderabad, and a member of the Indian Law Society, Delhi. So he has brought laurels to the department, and his contribution to the department in tax administration has culminated in his elevation as the Chairman Settlement Commission, which is accorded to people, to officers whose ability and integrity is recognized at the highest level. Having said all these things about Shri Honorable Chairman, Settlement Commission, I would like to say something which is personal to me, and that is, we are both from the same city, that is Ranchi. And therefore, my appreciation for him is not only in an official capacity, but in a personal capacity as well. So without speaking any more about the settlement process, I would immediately like to hand over to the chairman so that he can, in his own lucid style, elaborate on the system of settlement under the Income Tax Act. Thank you, sir.
Thank you so much, sir. And now it's time for us to listen to Honorable Shri A.K. Jaiswal, Chairman, Settlement Commission, on the topic of the day, Concept of Settlement under Income Tax Act 1961. The audience is eager to listen to you, sir. I would unmute Mr. Jaiswal.
Yeah.
So I think I could locate you.
Yeah, now you can.
Thank you.
Yeah.
Thank you.
So can I begin now? Good afternoon to everyone present in this webinar. First and foremost, this webinar was, to host this webinar, I must express my gratitude to Shri S.K. Tulsian, who first broached the subject and wanted me to be a part and parcel of this webinar. And I gladly accepted, because I knew this would give me an opportunity to express myself to the persons who have joined this virtual meeting. There is so much to cover, but I am going to restrict myself to a few things which I consider it essential to understand the Settlement Commission, both historically as well as in the current context. Historically, a creation of the statute in 76, we must appreciate that the fact that this whole organization was named as the Settlement Commission. The whole idea was to settle disputes. The whole idea was to give an opportunity to the taxpayers, give them one-time opportunity in their lifetime to come forward and make a declaration of their undisclosed income, pay their due taxes, and get back to their what they do their best, that is their business. I have been associated with the Settlement Commission in Delhi as a member, as a vice chairman of the bench 2, and then now as the chairman. And I find that we need to further understand the role of the Settlement Commission. Jokingly, I keep telling people, but it's not a joke actually. Many of us, or some of us at least, tend to feel that this is not a Settlement Commission, and I tell them this is not a disruption commission. We are all sitting here to settle an issue. It is the taxpayer's choice. He comes forward and makes a declaration of his undisclosed income, given once in a lifetime this opportunity. And all over the world, such arbitration, you can call it settlement, whichever term you allow it, it is carried on. And this is the most preferred form of adjudication. I will just divert for a moment. And if you see the Honorable Prime Minister's mandate, he keeps talking of ease of doing business. I honestly feel that the Settlement Commission, the role of the Settlement Commission actually falls into this huge circle of ease of doing business. What does the businessman want? Okay, for certain reasons, he has earned undisclosed income. And as provided under the Income Tax Act, he is coming before the Income Tax Settlement Commission with an application to show the undisclosed income which has not yet been shown to the assessing officer. Comes forward, pays the tax due, and goes through the entire process of giving submissions, of getting certain inquiries done through the department, coming and to the process of the courtroom proceedings, arguing his case, and replying to the representatives of the department, explaining things that how he has earned it, the what as they call it, the how the way the income has been earned. And here a little dispute arises because the department many a times is insisting on much more than the full and true disclosure of income not disclosed to the ITO. Here, the mandate states clearly that the taxpayer comes forward and makes an application, gives his full and true disclosure that this is the amount, this is and thereafter he says that this is the manner in which such income has been derived. That derived is a very important word which so many times we tend to miss out. He is supposed to fulfill these conditions, that he gives a full and true declaration. He makes a full and true disclosure of the income which has hitherto not been disclosed by him to the AO. And at the same time, he also gives the manner in which such income has been derived. And once he has fulfilled these two obligations, then then his application is first admitted. Then he goes through a process of entire checking of his accounts, his checking of his SOP, the checking of his how he has to give the SOF, and then starts a proceeding with where the commission, where the Act states that the commission is supposed to call for the records from the department, if at all required, and get necessary clarifications, get necessary inquiries made so that a reasonable settlement of the undisclosed income is made. Now the question here arises, how does the Income Tax Act completely come in between the settlement procedure and the various enactments in the... Now, I always tell my colleagues, and I always in my informal chats say that here there are three stakeholders. One is the applicant, the other side is the department, and third is the Settlement Commission. All three, it's a triangle. Now we do not in the Settlement Commission would like to be a part of the department in a way that we take the seat of the assessing officer and start assessing the income as per the Income Tax Act. No, that's not the job. I always feel that the job is that we settle the undisclosed income on a real income basis. We see most of the times we are giving by the honorable bar members that this is the assets which we have created, this is the incomes which we have generated, and this is how we explain the assets created. This is the undisclosed income which has gone into these assets. If these matches, the Settlement Commission should be fairly satisfied that the declaration made by the taxpayer is full and true. Not many times, but I have been given to understand that at times the Bar Association, members of the bar and the applicants, feel a little uneasy when the Settlement Commission takes the place of an assessing officer. I am sure in myself, I cannot be sure of others. They have their own other vice chairmen and members of the various benches, have their own way of looking at things. But in my view, we cannot sit in the chair of the assessing officer and start assessing the income as per the Income Tax Act. No, we are supposed to settle the income as per the application provided by the given by the taxpayer, and see if that application and see that the undisclosed income given there is full and true. If not, yes, ask the taxpayer that, my dear, this is a problem here. This is not full and true. You need to come out further, see your accounts. Many times you find that the taxpayers they realize that this is not what they had thought, and they do a recalculation, an authentic, genuine, true recalculation, and come forward and say this is a mistake which we did in the calculation of this income, and we would like to say that, yes, in the spirit of settlement, because that's what it's supposed to be, we further declare this income. Now, so it is this settlement procedure which actually makes a lot of difference when, and will actually fulfill the mandate of the Income Tax Settlement Commission. I would now I'll now request the chairman of the session to open the discussion to the members, and who may ask their queries, who may ask their questions. And the only caveat here is this, that I will find it very difficult to answer any question directly pertaining to any particular case, or I cannot answer a question on a specific application because each bench has the right to take a decision which they want to take. I cannot, as the chairman of the Income Tax Settlement Commission, persuade other members or other benches to follow a particular stream of law or thought in their orders. They are at liberty to take a decision as per their wisdom. So I will not be able to comment on any particular case, or I cannot comment on a particular application of a particular section to the settlement proceedings. Now the chairman of the session can take up the matter.
Sir, I want to unmuted you. Yes. Mr. Jha.
So the questions from any of the participants who are attending this webinar, they can send it by way of a WhatsApp to me so that it is forwarded to the chairman for comments.
Unmute ho gaya na? May I raise a question to the Honorable Chairman of the session to be put up to the Honorable Chairman Settlement Commission? In an application, when an applicant makes the application, he makes a voluntary disclosure of his income. Such an income is subjected to examination by the Settlement Commission in camera, and then the Settlement Commission proceeds to decide about the final quantum and default stage. The point which I am asking is that a undisclosed income is positively not supposed to have any counter verification because these are not provided in the regular books of accounts. So when a VDIS is made, can a investigation can be ordered when the applicant himself mentions in the application that no verifiable records are available? So I would request Honorable Chairman to enlighten us in such a situation when a voluntary disclosure is made. Can a commission order any investigation in respect of the source of the same?
I am very clear on this subject. The taxpayer has himself come forward and has made a declaration that this is his undisclosed income. Now that he took the benefit of the VDIS, a voluntary disclosure scheme, in which he came up with disclosed income, as I understand, and most of the disclosure schemes were also there during when I was in the department. Even the VDIS records are confidential records. This is not open to the public. Now he makes a declaration in this VDIS scheme of certain cash, jewelry, etc., etc., and that is VDIS is accepted by the department. Now, where is the question of further making any inquiry that this VDIS, which was made by the applicant and accepted by the department, needs further inquiry or investigation? In my view, I think it is not legally sound and correct.
Thank you, Honorable Chairman. Thank you.
I hope I'm clear.
Yes, Your Honor. Thank you. Very, very, very good answer. The other issue which is agitating the mind of the applicant today is in respect of the time barring provision. Because of this pandemic, the time which is expiring on 30th June, most of the cases are hanging for hearing in the courtroom. Now, there is a judgment of Supreme Court in the case of a Star Television, where the Supreme Court has said that if it is not the mistake of the applicant or it's not the failure of the applicant to respond to the notices of the commission, then the abatement under section 245 HA will not take place, because the abatement cannot take place without the fault of the applicant. So in a situation like this, when the applicants are not able to attend and the bench is not able to hear in the courtroom, whether the time will get automatically extended and the applicant will be entitled to have their cases settled beyond this period of 30th June.
I am again very clear on the subject, Mr. Tulsian. I don't know, somehow I've become very clear on a subject. I may be right or wrong, but I'm very clear whether I'm right or whether I'm wrong.
Thank you.
Before I answer this question, I should have made this open to the participants that in the first fortnight of May, I had moved to the Government of India that the 30th June, which has been given as the date of proceedings getting barred by limitation, kindly extended. I have been given to understand that the government has actively considered this in a positive manner. And sooner rather than later, we will get this notification for extension. So there should not be any cause of worry with the participants. Let's hope in a coming few days, we will get this notification and the time would be extended. And at the same time, I also want to make it clear to the participants and through you to the applicants that I have also moved a proposal to the Government of India that, like in other courts, the Income Tax Settlement Commission, a virtual hearing should also be allowed, and by making certain amendments in the rules so that personal hearing through the applicant or through the authorized representative and the virtual hearing can also be added to this. That will make things much easier and that will obviate the problems of the taxpayer or the councils traveling in this very difficult circumstances and appearance in the court. So I think first, very soon we will get the notification regarding the extension of the time barring date. And I hope to push very hard for this virtual hearing also and an amendment in the rules so that we can be able to do it. With these two, I think most of the issues should be sorted out. Any other suggestion?
Third most important thing, yes, which I would like to mention is that under section 245D3, there is a 90 days cap given for investigation to the department under the Act. So if time barring period is already near and 90 days time is not available, can the commission in such a situation order an inquiry under section 245D3 when the statutory time limit expires for completing the settlement under section 245D4? Is it not a thought out procedure that immediately after receiving Rule 6 report and 2C order, the commission should apply its mind so that within time frame they can order an inquiry if they want to do so after examining the record of the commissioner? After almost reaching the time limit,
true,
can the commission order an inquiry under section 245D3 when 90 days time is not available?
I would, Mr. Tulsian, I would take some time to consider this, get it examined, and then revert back to you and to the Bar Association on this subject.
Yes, sir.
But at the same time, I would like to say that in such circumstances where things are absolutely in a disarray, and it's a near health emergency. It is a health emergency. We need to take such decisions which are not against the taxpayer's intention to come to the Settlement Commission and get his undisclosed income settled. I think that should not be a problem, and I'm sure I'll also get this examined because I can understand that the 90 days period becomes so close or it overlaps and there is a problem.
Thank you. Thank you. Thank you. Now the chairman of the session can take up on the matter further for questioning.
Sir, there is a question from Mr. Bhaumik that if the SSC is under income tax investigation, can he approach the settlement commission?
No, if there is a pendency of the case, he can always do it.
So, probably, sir.
You see, he can come to the commission at any given point of time, provided there is a case. And that has been amply defined under the Income Tax Act.
Thank you, sir. Probably, I mean, this amply answers the question raised by Mr. Bhaumik.
I hope it is satisfactory.
Yes, sir, it is. And probably Mr. Bhaumik is also satisfied. So I will now, there is a question from Mr. Agarwal, but he has not sent it in the chat box, so I can't probably articulate what he wants to ask. But
Sir, can I ask orally? I want to raise a query orally, Your Honor.
Please go ahead.
Can I be permitted to ask a question orally?
Yes, please go ahead.
Sir, suppose in the course of search, some documents are found and it is seen that the SSC had taken loan and also refunded loan in cash. Now he wants to come out clean with the settlement commission by approaching the settlement commission by offering the loans taken, the peak of the loan taken as income. Sir, what will be the status of penalty under section 271 capital D and 271 capital E? I mean, what is the general approach of the settlement commission? Because it is not, in general, it is not possible for a SSC to pay tax and then also to pay both the types of penalties. So that might be preventing SSCs from approaching the settlement commission. Sir, we want to know what is the approach of the settlement commission in such cases.
Mr. Agarwal, if I may intervene, this question, this is not the right forum to ask this question because as the chairman has correctly stated right at the beginning, that the different benches of the commission are at liberty to take decisions as per the facts and as per the law understood by them. So for the chairman to say as to what will be the view of commission on a particular issue, probably this is not the right forum to ask this question. I will request all participants to restrict their questions with regard to the process of settlement. The chairman, it will be difficult for the chairman to give answers to specific questions relating to specific issues because the issues are within the purview of a particular bench hearing the settlement application, and therefore the questions should be with reference to the process of settlement rather than the specific issues of settlement. I will request the Honorable Chairman Settlement Commission to give his views as to whether my understanding of the question is right or not.
Am I audible?
Yes, sir, you are.
you are right. You see, what happens is that each bench is at liberty to take a decision on a particular application of a section. We must understand that each case is unique. Each circumstances in the case could be unique. What are the entries in the book of account found unique? What is business being carried out? The business compulsions would be unique. So to give a flat dictum on a particular application is actually not correct. This is my understanding. So each bench would understand the facts and circumstances of the case very well. Now, for instance, something as basic like the manner in which such income has been derived. Now, the catchword is derived. Now, each bench can have a different understanding of this, because if you recollect, in earlier in various other sections, certain deductions were only allowed when income was derived from that particular manufacturing process. Now, here the manner in which such income has been derived has to be made apparent to the Settlement Commission. I know that it is open to interpretation, but that is what it is all about. That is why each and every member and each and every bench is at liberty to take a decision on the facts and circumstances of the case. I hope it's okay now.
So, any further question from the participants? So let me ask you a question from my side, if you'll permit me. We conducted some outreach programs in places like Guwahati, Ranchi, Patna, Bhagalpur, Siliguri. As a result of those outreach programs, sir, we started getting applications, though not large in number, but definitely applications from Mofussil stations also, from remote places also. So, sir, in my view, the utility or the significance of the settlement commission or the settlement process has probably not filtered down to cities, non-metro cities, so to say. So, in your view, sir, should the commission as an institution should not take a proactive step in reaching out to the bar associations or taxpayers in smaller cities, so that the potential of this institution, the sacred institution, is utilized to the fullest extent?
Yeah, Mithilesh, it is a very, very relevant point, because what is happening is that so many applicants who would like to take this opportunity, to a lifetime chance to come to the commission, are not able to come because they are in far-fetched places, and they have not been able to take the opportunity to come to the commission. In fact, this outreach program must be carried out by each and every bench all over the country. And full effort should be made by the concerned bench members to take out time and talk to the bar associations of smaller places. At the same time, there has also been some suggestions, but nothing concrete has been sent by the various bar associations, that this threshold should be brought down a little. What happens? That will then give the opportunity of smaller taxpayers also, a little smaller taxpayers also, to come to take this opportunity. Now, it is so, I mean, everyone need not have an unaccounted income of say 50 lakhs, 1 crore, or, as above the threshold. Even if they have a smaller amount, instead of going through the regular process of assessment and getting their incomes assessed, they can quickly come to the settlement commission, and in fact, this will be adding to the ease of doing business. That the concept of ease of doing business would be substantial, and this would spread out to the smaller cities as well.
In the context of the Honorable Chairman, may I ask a question?
Please.
In the context of Honorable Chairman of the session, Sri Mithilesh Jha's suggestion and your response to that, I have a very simple question. In all these small places, when you conduct a survey, you find that 50 lakh rupees of stock is excess, or certain house has been built and that has not been disclosed, or some jewelry has been found which has not been disclosed. But it is the applicant who is aware how this income has been earned, which has transformed into the stock or into the house property or into the jewelry. When he takes recourse to settlement commission, he has to state the manner in which such income has been derived. Now, his obvious source of income is, say, having a textile store, or having a kirana store,
correct,
or like that. So his source of income is from that source, and he discloses that this has been derived out of my excess income earned from this business of kirana or from the cloth store, and likewise he states the manner and comes before the settlement commission. Now the department says that since asset in form of undisclosed income had been found, therefore the provision of section 115BE or section 69 or section 69B or section 69C, these provisions should be applied. Now, Your Honor, in a small place, these sort of things, evidences cannot be preserved in respect of undisclosed income. Now he is coming before the settlement commission. Prime condition of coming to the settlement commission is manner in which income has been derived has to be stated. He has stated, he made the voluntary disclosure. Now, Your Honor, whether the commission will apply section 115BE or will accept his disclosure and proceed to settle his case on the basis of normal rate of tax.
I would only respond, Mr. Tulsian, on this, that 115BBE has been a matter which has also been adjudicated by different benches. In Delhi, in Bombay, I don't know about Calcutta, I got no idea. But a consistent approach has been taken, as far as I know, because I don't track the judgments given by the various benches. But there has, as I understand, a uniform application of this section. And I don't think that the application of this section made by the benches have not been acceptable to the taxpayers or to the department. The department, as I understand, as of now, has not gone into any review of such orders passed by the subcommission. So I don't know. I don't think it should be rather a matter than a matter needs to be unsettled.
Thank you. Thank you. Very well said. We are much obliged.
Thank you.
This clarification will aid to number of applications in the commission.
Yes,
This will give lots of confidence to the applicants.
it is a stand which has already been taken by the various benches.
Thank you.
Mr. And both in Bombay, as I understand, I keep meeting them on various occasions.
Yes.
But I don't know of particular cases, but I know that this stand is now taken Bombay benches, for the Calcutta benches, and also on Delhi benches. That
No, because the problem is, Your Honor, some bench is insisting that since you are making a disclosure before the commission, and unless you substantiate your disclosure, we will take a view that it is a undisclosed income manner or the source of which has not been explained. So therefore, section 68 to section 69C will apply. Now you just think who will come before the commission if you want to take this sort of hardened view in respect of a disclosure made before the commission.
Mr. Tulsian, you have to that where in law is the onus on the applicant to substantiate?
No, nowhere.
The law is clear. You have to make a full and true disclosure
Yes.
of the income which has not been disclosed before the AO. It should be full and it should be true. And you should give the manner in which the income has been
Right.
I again insist on the word derived.
Right.
Yeah, just forget it.
Yes.
And once he has done it, his job is over.
Correct.
Maybe, I don't say that, maybe during the processing of the application before the settlement commission, there may be occur where he has something left out or something has been not been correctly construed by him. And so he would say that in the spirit of settlement, we would like to come to this thing. It's possible. It is possible.
That's right. Right. True. Correct. Thank you.
Anything else?
No. It's wonderful.
If I can
Wonderful.
Yes.
We are very happy. Yes. Thank you.
Chairman, sir, are we done with the interactive session or we have more questions?
I don't see any more question in the chat box. So I presume that there are no further questions from the participants.
So with that, with the permission of the chair, sir, yes.
Can I take a minute?
Yes, sir.
If permitted, I will try to take the names of those soldiers who have laid down their lives, the 20 soldiers who have laid down their lives, and pay homage to them. They are Naib Subedar Satnam Singh, Naib Subedar Mandeep Singh, Sepoy Kundan Kumar, Sepoy Aman Kumar, Nayak Deepak Singh, Sepoy Chandan Kumar, Sepoy Ganesh Hasda, Sepoy Ganesh Ram, Sipahi KK Ojha, Sipahi Rajesh Urun, Sipahi CK Pradhan, Naib Subedar Nandu Ram Soren, Havildar Sunil Kumar, Colonel B. Santosh Babu, Sipahi Jai Kishore Singh, Havildar Bipul Roy, Sipahi Skurtej Singh, Sipahi Ankush, Sipahi Gurvinder Singh, Havildar K. Palani. They have laid down their lives for us. These people need to be given a special homage by every citizen, which includes all of us. Thank you very much.
With this and with the permission of the chair, I would request Sri Manoj Kataruka, the Joint Secretary of the Income Tax Bar Association, Calcutta, to give the formal vote of thanks and end the meeting for the night. Manoj.
Thank you, Siddharth. It's a privilege and honor for me to propose this vote of thanks on behalf of the Income Tax Bar Association, Calcutta, jointly in organization with the Tax Association of Bengal and the Legal Relief Society. I would like to thank the chief guest speaker, Shri A.K. Jaiswal sir, Chairman Settlement Commission. With his rich legacy of experience in the income tax department and the deliberations which he has given on the concepts of settlement in such a lucid and easy manner, which he has explained of ease of doing business. Settlement is on a real income basis, and the main thing which he explained, that settlement commission does not act as an assessing officer. So I think with these, with his deliberations and this, the participants would definitely approach the settlement commission in this manner. And I, on behalf of the association, I thank you, sir, for your deliberations. I also want to thank the chairman of this webinar, Shri Mithilesh Jha, CIT Exemptions, who is known for his prompt delivery of justice, as our president had mentioned earlier on. And he has been a secretary of the Income Tax Commission in this level of CIT, and that is why he has acted in such a great manner as a chairman and conducted the session in a fantastic manner. And thank you very much, sir, for your time and your presence here. The chairman of the West Bengal Bar Council, Sri Siddharth Mukhopadhyay, Siddhartha, who is also the secretary of the Tax Association of Bengal, for joining hands with our association in conducting this third webinar. We have been doing it like we have been doing this as a third webinar, and Siddhartha with his organization TAB we are doing it jointly. And I will also like to thank Shri R.D. Kakaraji, President of the Legal Relief Society, who has also joined hands in this conducting this webinar. I would like to thank our President of the Income Tax Bar Association, Shri S.K. Tulsianji, for putting all his efforts in organizing this seminar, in bringing the speakers and jigsaw's together. Very much. I would like to thank all the participants, members of the Bar Association, Tax Association of Bengal, Legal Relief Society, for having spent your valuable time and spend this evening. And I'm sure by the deliberations of Shri A.K. Jaiswal sir, you have been enriched in this meeting. Thank you very much.
Thank you, Manoj. Thank you so much. Before we go for the final ending of the session, let me announce that the next webinar would be on the 20th of June, Saturday morning, 11 o'clock, on the topic, the development of case laws from independence to present day, evolving legal landscape of India. And we would have as our chief guest speaker, former Attorney General of India, Honorable Shri Mukul Rohatgi, Senior Advocate, Supreme Court of India, and it would be chaired by Honorable Principal Commissioner, Chief Commissioner of Income Tax, Shri Vishwanath Jha. I would request all your participation and all of you to please the word of mouth publicity for this. It's a grand occasion that we're looking forward to on Saturday morning, and I expect all of you would be there with us. Now, with the permission of the chair, sir, Shri Jha, can I end the meeting for all and call it a day?
Thank you. Thank you.
Thank you so much. So we end the meeting for all, and we look forward to meet you on Saturday morning at 11 o'clock. Thank you.